Good afternoon, everyone. Welcome to Asian Exporters Chamber of Commerce and Industry, authorized by the Ministry of Commerce and Industry, Government of India. I am Advocate Rohini, representing the legal wing of AECCI. So, under the esteemed leadership of our Honorable Board Chairman, Mr. Jahir Bukhari, AECCI has been at the forefront of empowering exporters, promoting international trade, and offering legal support to businesses. ACC Legal Wing is dedicated to addressing the legal challenges faced by the exporters. We provide guidance on commercial dispute, arbitration, and compliance with trade regulations. Our goal is to ensure that businesses can navigate the challenges of global trade with confidence and clarity. So it's my privilege to host this session, Ask Me Anything on Arbitration, where we aim to facilitate a deeper understanding on arbitration as a powerful tool of dispute resolution. Today, we are here to explore how arbitration serves as a crucial mechanism for resolving dispute, especially in the realm of international trade. Arbitration not only saves time, but providing confidence to businesses to operate globally. Today, we have Ms. Swarnalata, Executive Director of AECCI, and Advocate V. Inbavijayan, Senior Advocate and renowned expert in arbitration. He is also an empanelled arbitrator with AECCI International Arbitration Centre and has an impressive track record in both domestic and international arbitration. With his experience as a sole arbitrator and a panel of arbitrator in over 400 domestic and thousands of small claim cases, and he also deal with 17 international arbitration and as an emergency arbitrator in domestic institutional arbitration. So his expertise covers a wide array of fields, including international arbitration, maritime dispute, intellectual property right, construction disputes, and many more. Today, he will guide us through the legal aspects of arbitration, including drafting effective arbitration process, enforcement of arbitral award, and arbitration for efficient dispute resolution under the Arbitration and Conciliation. So I welcome Ms. Swarnalata ma'am to introduce about AECCI and International Arbitration Centre.
So, good morning, Rohini. Thank you. Good morning, sir. And though Rohini has already briefed about everything, then too, first of all, I would like to extend a great warm welcome to Advocate Inbavijayan. And thank you, sir, for taking out the time out of your busy schedule on behalf of AECCI, on behalf of AECCI management. We extend you a very warm welcome. And before moving ahead, I would just like to there seems to be some issue with my camera. I think I am audible to you all.
Yes, ma'am, you are audible.
Yeah. So I was talking about the brief introduction of the AECCI. AECCI means Asian Exporter Chamber of Commerce and Industry. This is a decade-old organization, and we are dedicated to promoting the international trade. We are proud to be recognized by the Ministry of Commerce and Industry, Government of India, to certify the origin of goods being exported from India. Again, we are here to serve the needs of exporters and importers and helping them to handle the complex issues of business. At AECCI, we are committed to promote the safe and fair trade practices. To achieve this, we continuously work towards implementing the different activities and programs, and we focus on building the awareness about the trade policies, procedures, and dispute resolution mechanism like arbitration. So this is our, you can say, effort. This is our simply to promote the international trade. And one such initiative that I would like to talk about is the inception of our International Arbitration Centre in 2019. So this actually got operational in 2023. And today, as Rohini said, we have number of arbitrators empaneled with us on IAC, and today we are having Advocate Inbavijayan. He is an expert arbitrator who would be throwing the knowledge on arbitration, its implementation, and of course, how this can be benefited to strengthen the trade ties. So whether you are an entrepreneur, you are an exporter, or in corporate governance, this is going to be a very good session for you all, and this will be providing you the wealth of knowledge regarding the implementation of arbitration mechanism. So I would hand over back to Rohini She'll be taking care of the session here onwards. Rohini, welcome back.
Yes, thank you for a introduction about Asian Exporters Chamber of Commerce and about the International Arbitration Centre. And Advocate Inbavijayan, thank you for your presence today. And so without delay, let's begin with our session, sir.
Yes.
So the first question I want to, that is, so many businesses overlook including an arbitration clause in the agreements when dealing with letters of credit, assuming that letter of credit itself serves as a guarantee for successful business transaction. So what is your opinion on this? Do you recommend businesses to still include arbitration clause, or they can only on the letter of credit? So what is your opinion on this?
Yeah. Thank you, Rohini and AECI for giving this opportunity to share about the interesting nuances about arbitration and how it's going to facilitate the business. Getting straight away to your query or the query of many of the members or the exporters or importers, LC, that is a letter of credits, which is a very, very common document or negotiable instrument in the language of the lawyer, which is used in this market, ensures that transactions obviously are honored based on strict compliance with documentary requirements. This might be limited to some financial aspects. And if you see, LC as such doesn't address the broader disputes such as fraud, the quality defects, the delay in delivery, or other contractual breaches. These are things which we are missing out in looking into the particular negotiable instrument LC. There was a day when these LCs had a lot of discrepancies. If you look into the LCs, every sentence they'll have discrepancies, whether it's applicant bank or the confirming bank. No, it is not like that. Those documents are now perfect, but still the contractual breaches are not addressed in an LC.
Yes.
How to handle this? Here, we do have these arbitration clauses to handle, which effectively going to enforce the framework for resolving the conflict. Very important.
Right.
There is still a greater say about what is the dispute. When you look
Yes.
into the concept or understanding of the word dispute, we had to end up in multiple common law judgments, and that too as exporters or the in-house team, legal team, we all have to be familiar about the term dispute. What is actually dispute? Most of the cases, they try to bring that a premature stage you are taken to the resolution process.
Right.
And when you're looking into the LCs, it doesn't address the aspect which is beyond the financial one.
Right.
Multiple things are there. We have these contractual terms, duties, and obligation. When there is a breach, if we have an arbitration clause, obviously that provides the parties to flexibly choose the governing law. There is a law which is going to deal the dispute, which is going to bring out the arbitrators who are going to be the presiding officers or the adjudicators who are not the judge. We are not going to disturb the national courts, and our commercial disputes can't be taken so comfortably by the courts because they lack the domain expertise. They do have the knowledge, but the domain expertise is not available in the courts. The person who can understand the LC is a domain expert would be appointed as an arbitrator if we have a clause. And there is a procedure which is totally flexible happening outside the court, but still recognized by law. And finally, we do have the basic C's we call confidentiality and consistency. Our dispute is kept private, it is kept confidential.
Right.
It is not a public hearing. When you take our disputes to arbitrator by based of an arbitration clause, it's kept confidential and it's also efficient. One thing in the exim trades, confidentiality also might create some problem. We can't just come out with a party who's a prevalent litigant who always end up with some negative obligations which are not feasible to be taken up. but still the confidentiality is very much required, which makes these relationships sustain. Very important. In export-import, the parties' relationship is very important.
Very important.
In arbitration, we'll eventually get, particularly in LCs. And here, one thing before going to the next query to address, what would be the major advantage of incorporating the arbitration clause alongside the LC? That's very important.
Yes.
It is a reliable mechanism for resolving the dispute that may arise during or after the transaction. We have to understand at the time of entering or preparing the LC, we are in a honeymoon period.
Yes.
We need to have a relationship. We are sharing the risk among ourselves. The two parties are sharing the risk.
Right.
This risk is not exposed at the point of entering the contract. The dispute might arise in the future. A future dispute can also be dealt by arbitration. And interestingly, we are not ending up in any country courts. When you're dealing with a country which is a Latin American country, in Latin America, predominantly the courts are considered to be hostile. They go with their parties, their region. And when we opt for arbitration, incorporating an arbitration clause, we can find a neutral place. We need not end up in a place like Latin America or in a place like India. In global jurisprudence, India also is considered to be a vulnerable place when it comes to the court system. Delay. Delay is a major problem in our country. Here, when you're opting for arbitration, when we incorporate an arbitration clause, your disputes would be taken to a neutral place wherein there will be an arbitrator who can understand the law. There will be an arbitration who have a procedure which is less cumbersome and ultimately an outcome which is also enforceable, very important, or executable. A simple language, it's executable. This is one advantage. The second one, it minimizes the risk. It also enhances the legal certainty as well as strength the overall transaction framework. In a technical perspective, the transaction framework is structured well. And the final advantage, what I felt when we are going to deal with incorporating an arbitration clause alongside an LC, there will be a balanced approach to manage both payment security as well as potential conflict, ensuring reliable trade relations. It's all ending with a trade relationship. And when we are incorporating an arbitration clause, eventually the payment mechanism or the security as well as potential conflict would be addressed. In that way, I feel, in my personal opinion or a broader opinion from ADR practitioners, that kindly incorporate an arbitration clause, and that too when you're having institutions like International Arbitration Centre attached with AECCI, their model clause can be very well incorporated in the LCs.
Okay. So your insights on balancing the use of letter of credit and the arbitration clause are incredibly valuable for our audience. So thank you. And moving to the next question, sir.
Yeah.
So if an arbitration,
Yeah.
Yes, ma'am.
Yeah, no, that's what I was saying. Sir has said about the financial limitations of LC. There is a simple term whenever we deliver some lecture and all about international trade, we say LC deals with documents only, not with the quality of the product and other disputes. As Sir said, so very rightly said, people need to be aware about the LC and of course incorporating this arbitration clause. This is very important. So yeah,
and also
one more thing I have to add. I'm not just an expert in that particular component. Doc decks. Many of you would be familiar with the doc decks, DOC, DEC, which is quite prominently promoted by the International Chamber of Commerce.
Right, sir.
That particular component has to be effectively dealt only by arbitration. Arbitration is the only remedy for resolving the disputes emanating from doc decks. And here, we also have to look upon the institution framework, how IAEC has been structured. IAEC, in my understanding, is an exclusive, a sector-specific. That's very important. In a multiple arbitration institution, if we have an arbitration institution which is very sector-specific for the traders, that would give a proper solution for the dispute Why? Because the panel of arbitrators would be the domain expert. Very simple. They can understand what is
Yes.
LC.
LC,
Yes.
right. Domain
Yes,
expert,
right, sir.
that is very important to understand. One should be. And while choosing your arbitrator, people should also be careful about that.
Yes, sir. So thank you, sir. So moving to our next question. If an arbitration clause is not included in the agreement, so what are the options available for the businesses to resolve the dispute under the Arbitration Act, sir?
One thing we have to be very clear. If there is no arbitration clause or an agreement, then we cannot arbitrate. A
Yes.
simple answer is that. But,
Yes.
but still, there is a possibility. We call that to be a submission agreement. Once a dispute has arisen, and
Yes.
if the parties are keen to resolve the dispute through arbitration,
So,
no doubt in the trade, most of the international trade, most of the parties won't be interested to end up in another country court. No
right,
one would be interested.
right.
In such a situation, we have an aspect of submission agreement.
Submission.
After a dispute has arisen, we can enter into submission arbitration agreement. And if you look into our Indian Arbitration Act, in India, there is an arbitration law which is christened as Arbitration and Conciliation Act 1996,
Right.
which has seen 3 amendments: 2015, 2019, and 2021. And now there is a proposal, 2024 draft
Yes.
amendment is there.
Yes.
In all these, fortunately, they have not disturbed Section 7. Section 7 is about the arbitration agreement. Here, it is nothing but an arbitration clause, simple understanding.
Okay.
An arbitration agreement or a clause can also be signed or agreed by the parties even after a dispute has arisen. That is the definition they are trying to give. And here, if the parties even couldn't agree or couldn't come to a conclusion for an arbitrator or in a submission agreement, they can very well approach the court. The court would help to appoint. This is one option. This is a default option under the law. And the law is also giving another opportunity. When you look on Section 11 of the same Act, the High Court, when it comes to domestic arbitration, or the Supreme Court can appoint, or as a default authority. It doesn't end there. They add two more things, or any institution or any party. The default appointment can be done by the High Court or by any institution or by any individual. That's what the term given in the provision under 11.
Okay, sir.
Here, the option is there for the parties to approach the institution also if the court is not in a position to appoint.
Yes.
All these are there. For domestic, we can approach High Court. For international, we can approach Supreme Court. And we can also stretch this to the institution. Here, institution like IAC of AECCI can also act just as an appointing authority. It's not that an entire arbitration process should be handled by IAC.
Right.
Only as an appointing authority. IAC is there when the parties are not already chosen an arbitration clause, and if the party later comes to the submission agreement, IAC can help them to find out an arbitrator, a neutral, independent, unbiased, impartial arbitrator who will be appointed by IAC. And here we can also take into consideration the latest development, that is mediation.
Yes.
I think AECCI also has that services provided through IAC, because there is a new act which is yet to be enforced as total. Mediation Act 2023 is there, and it is going to surpass the conciliation. Here, there is high possibility of settlement, and they facilitate settlement only. Finally, what I feel, even if you are not having an arbitration clause, we can still rely on an interesting component given in Section 89 of the Civil Procedure Code of India.
Okay.
In 2000 or 2002, there was an amendment brought in the Civil Procedure Code, which is highly legal, even though for an audience to understand, you can just Google Section 89. In 89, you can find an answer. Even if you file a civil case, a civil suit in a court in India, the courts can very well refer the matter to either arbitration or mediation or conciliation or even a very simple process of Lok Adalat.
Yes,
Here
right,
we
sir.
have arbitration and mediation included.
Okay,
We
sir.
do have an opportunity even if you are not having an arbitration clause for
Arbitration clause.
domestic.
Yes,
In
understood.
exporters, you have, if you are a merchant exporter, you have to obviously prepare all the products or the goods. Those would be predominantly domestic. And those transactions, you'll end up with some contract, and those contract might be related to this trade, and that can very well be facilitated domestically with either of these process. Even if you are not having a arbitration clause, the courts also would insist. Why to go to the courts? Even before going to the courts, you and the other party can very well enter into a submission arbitration agreement or a submission mediation come arbitration agreement.
Right.
So,
And so for
thank you for your.
yeah. For entering into the submission agreement means how they can proceed, to whom they need to approach for this, sir.
Here, submission agreement is all created by the parties' mutual consent,
Okay, sir.
the disputing parties. Predominantly, we can't just expect both the parties to come to a conclusion to go to a process which is quite less cumbersome. But
Right.
still, it is a responsibility of the parties to negotiate, or if the parties, both the parties are members of some organization, a professional body. AECCI is one such body, FIEO, like that, many bodies are there.
Right.
If those bodies are there, every bodies eventually insist and advise the parties that you better don't enter into the courts.
Yes, yes.
Yes, right,
And
sir.
one thing more I would like to add here, sir, because you have spoken about this thing. In the past years, I would say we have come across 8 to 9 such cases where there was no arbitration clause was incorporated by the parties. And later on, they, of course, they went to courts and all. And as far as my knowledge is concerned, this ended like nothing. They couldn't achieve anything. They couldn't reach to any solution. So this is very important question, and sir has handled this very, explained this very like in detail. So Rohini, you can take up now.
Yes, sir.
Yeah,
So,
and one more thing before Rohini and ma'am, to supplement this, submission arbitration agreement would be quite a hard task for any party to accept. But it is all we have to make the parties understand, or the audience or the exporters or importers to understand that we need to have a quick remedy. We need to have a cost-effective remedy. We need to have a remedy which is facilitated with total confidentiality. And finally, we need to have a remedy which is less tested by the court. That is very important.
yes, sir.
If you are going for arbitration, and if the probabilities or the final outcome is challenged on very limited grounds, no party would be hesitant to take it.
Yes, right, sir. So that is many of our exporters need to know about this thing, because in most of the agreements they missed, or they don't know the importance of arbitration actually. So thank you for explanation and understanding the alternative options under the Arbitration Act for crucial businesses in such situations, sir. My next question is, so what does arbitration rules say about time frame within which a business can initiate a claim for payment recovery from international buyers? So what will be the time frame for the businesses?
Okay, fine. When it comes to the time frame, if we are dealing in a domestic aspect, we have to literally take into consideration the 3 years time frame, which is given under the Limitation Act 1963 of India. The 3 years time from the date of the actual triggering of the dispute or the disagreement between the parties or the breach. But internationally, it differs from jurisdiction to country to country. The legal language jurisdiction. If you're going to deal with a Chinese party and your arbitration process is going to happen in China, The Chinese law gives an option for the limitation period to be like 6 years. If you go to country like France, it differs. It's 8 years, some 12 years. Some countries don't have any time frame.
Okay.
Predominantly, when you look on in international business, mostly it evolves on the Incoterms. That's a base. Incoterms or the UCP 500 rules
Right.
when it comes to customs or the applicability of those rules. Here, we all end up with ICC's guidelines,
Right, sir.
International Chamber of Commerce. And ICC arbitration rules do not specify a time frame. We need not worry. But most of the jurisdiction of the countries, minimum it would be 3 years,
Okay.
and it can stretch beyond. Very rarely countries would have 6 months or 1 year time duration. That depends upon the place. But initiation process, when it comes at least in the arbitration agreement, we have to be very particular on the place where we are going to arbitrate. When you are going to be facilitated by IAC arbitration, IAC can arbitrate in any part of the world. It doesn't mean that IAC secretariat is in one city and they can provide the service only within that country. It is not like that. IAC can provide the services across the globe. The only thing is that it shouldn't violate the local arbitration law as well as the substantive law or particularly the limitation law. And when it comes to which place you are choosing to arbitrate, we can rely on the time frame. And arbitration rules of institutions are so flexible so that it can adopt. Accordingly, we can even change the jurisdiction of the particular dispute resolution process. It might be a hybrid, but still it is possible. Here, we have to also look into the very basic substantive law, that is a contract law of the particular place. The contract includes a provision for a time limit to initiate arbitration. Very important. Most of the contract, you can say the word time is the essence of the contract would be mentioned. The buyer would specify, we will be very particular on the time frame when it has to be delivered to that particular buyer. And if there is going to be a violation, the triggering starts from that time frame. And there is no specific understanding of the limitation period. It all differs from country to country. And when you're going for arbitration, we have that flexibility to even commence that particular date, that is a cause of action, from when the dispute arises. From that time, depending upon the local laws, the municipal law of that particular place, we can very well invoke the arbitration, taking into consideration the arbitration rules. The very important point here is that as a lawyer, what I'll suggest is that the businesses should promptly initiate an arbitration. Very important.
Yes.
Yes.
Even if you have a clause, it is your responsibility to invoke in a proper manner according to the local laws as well as the IAC arbitration rules.
Right.
Once a dispute arises, it's very important to avoid losing the right time to claim or facing delays. If you are the defending parties, you need not worry. You'll be the happiest person. You enjoy the time frame.
Right.
Because always there will be a lacuna from the party who wants to invoke. But party, and if you want to invoke, your arbitration clause would help you try to invoke at the right point of time so that you can avoid losing the right to claim.
Right.
Or else it's very dangerous. The limitation laws of every country would apply. Even the IAC arbitration rules are very clear on the limitation part.
Yes, right, sir.
Right. And if we say, like, sir, in India, RBI has fixed up the time frame for export and import payments, 9 months and 1 year, considering that also if you have arbitration clause, so it is better the moment you just get to know about the dispute, it is always good to take the corrective step immediately.
Yes. And when we are looking into the RBI guidelines and other norms structured by the institutions which are involved, it is within the scope of the municipal laws, the domestic law.
Yeah.
And the domestic law, fortunately, in India gives a 3 years time period.
Yes, sir. 3 years time.
Prevails over the bylaws. But be careful when we are going with foreign parties and a foreign jurisdiction. When you're going to deal, that country local law applies.
Applies.
Yes.
Our law would have a limitations beyond the territory. It is not
Applicable.
enforceable.
Right.
Yes, right, sir. So the time plays a critical role in ensuring the success of arbitration claims for every businesses. So thank you for a great explanation, sir. So many of our trade members have concern regarding the enforcement of arbitration award. So that is the important thing that many of the exporters or the trade members are not aware, or they don't have a proper guidance to how this arbitration can be executed. So, and what are the procedures involved to ensure its strict implementation? So what is your suggestion on this, sir?
Okay, it is very interesting question put to a lawyer. Always a lawyer enjoys the final say when it is realized,
Yes.
when the outcome would be realized, when the money is going to come.
Yes, sir.
Obviously, if the lawyer is going to fix a contingency fee, he'll be happy for it. Otherwise, it is going to be the next layer of litigation.
Right.
Enforcement of an award.
Yes.
Here, we have to look into the award into two types. One is domestic award, another is award, at least in an Indian perspective. In India, when you look on the arbitration legislation, if you are going to deal with an arbitration, whether it is going to be domestic or international, if it is going to happen in India, the Indian courts look into the award as a domestic award. That means a simple understanding, once the award is there, the award for enforcement has to be a time frame that is 3 months. They have to wait. Once the 3 months time period is over for either of the parties to challenge that award, then the fourth month, that is also leverage, and one more 30 days is there. We can stretch it to 4 months. After 4 months, that award can be enforced in the courts. It is not going to be the arbitrator enforcing that award. The award would be enforced by the courts, the local courts, where the losing party has an asset. That's very important. The losing party asset might be, I'm in Chennai here. If the
Okay.
arbitration is happening in Chennai and both the parties coming from Chennai and the losing party has an asset in Chennai, then very well I can take it to the courts. There is a principal court which is going to execute in that particular jurisdiction. I can enforce it. Enforcement is similar to a normal court judgment. But for an award to be enforced, it is not in the hands of any stakeholders. It is all depending upon that enforcement code finding that particular party having the assets. That asset should be there. He has to be in a proper financial position so that we can realize. Enforcement is very simple, but still the losing party's asset should be properly identified and it has to be attached to get the money. This is what domestic award, very simple. But for international foreign award, if an arbitration, if you are getting involved, if you're dealing with Chinese party, you can't do an arbitration in India, not even in Singapore, in Hong Kong, or in mainland China. There is no option.
Yes.
All those contracts are standard contract. We have to end up with it. Still, we need not worry. As a losing party, the Chinese party has to bring that award not to the courts in China. They have to bring that award
China,
to
yes.
India and try to enforce. As an Indian party, if you are a genuine party and if you have a good case to defend, you have two options to challenge or that awards. One, in China, in the Chinese People Supreme Court, you have to make a challenge application as per the Chinese arbitration law.
Okay.
That you can very well set aside that award. Assuming that that award is upheld, it is not set aside, then the Chinese party would try to come to India and try to enforce. At that stage, still you have an option to object for enforcement based on certain grounds locally. In that way, as a losing party, you are safe. But as a successful party, how you are going to enforce, that's very important. When you are having an award against a Chinese party, example, you are winning that arbitration, you have an option to enforce it in any part of the world, wherever the losing party has assets, including China. And
Okay.
interestingly, India is one country who is part of a convention which is called the New York Convention for Enforcement of Foreign Arbitral Award.
Right.
Similar to India, there are more than 163 countries who have adopted and ratified that convention. That means if an arbitration award is given in one place,
Right.
and that place is in a member state of the New York Convention,
Right.
and that award is likely to be taken to a place where the assets of the losing parties are there, that country also is a member state, then your award can be easily enforced.
Right.
There is no additional procedure. You need not take it to the local courts to have once again a trial and enforce it. You
Okay.
can very well take that award as an award in that local country, and to a local court it can be enforced subject to available of the assets. This is legally viable. But the
Okay.
second thing, how to you are going to realize the money? It is
Yes.
all about the financial status of that particular losing party.
Yes.
Whether we are going to establish your rights or whether we are going to claim money, it's all depending upon what assets they have. Here, there is one greatest opportunity in arbitration. There is an interim measures of protection provision in the arbitration law as well as in IAC rules. During the arbitration or even post the arbitration, very well the parties can seek attachment of those assets.
Okay.
That assets, not only that assets, and when it comes to an award likely to be enforced or before enforcement, the challenge is being taken, the parties can very well seek the court's permission to give conditional order, assuming that some 50,000 US dollars is being awarded in favor of a party, and the unsuccessful party is going to challenge that award in a particular country, whichever country. It's not so easy for them to file an application or get an injunction for enforcement. When they are trying to get an injunction, the court would insist to deposit to the maximum of 75% of the awarded amount in the courts,
Okay.
the claim amount. With that, that amount is secured now. Awarded
Right.
75% is a good money, the
Right.
percentage. Sometimes even it would be 50, but still, even 50% is good. That
Right.
money is secured. And once all the processes get over, we have that money kept in the court, which we can claim it at any point of time once the challenge is completed or when we are going to the enforcement process. But still, we have to wait for that enforcement process. In India, the good thing now there is a 1 year time frame given for the courts to complete the entire process. But let's wait and see how the proposed amendments are going to come. For us to get the money, we have the New York Convention. Very simple. And when you are opting for arbitration, this convention applies. When you are not opting for arbitration, then whatever judgment you are getting from a country court, that has to be taken to another country. Once again, the trial has to start. Then only you'll get a final judgment. Then we have to go for enforcement. That we call it the enforcement of foreign civil court judgments. That was the earlier situation before the 1958 convention. But now 164 countries, this is a very interesting number. When your major trading blocs are within this, beyond these, there are some countries which are not member states. We need not worry. Even in such situation, we can have the arbitration in a place which is within the member states. That is the reason why most of the big arbitration in the sense your larger transaction going beyond $500,000 US, we are ending up in places like Singapore, places like Dubai, places like Paris, places like London, Stockholm, Hong Kong. All these are better places to arbitrate in addition to India.
Right. Sir, can I ask one more query regarding this? So if the losing party, so if they got an award and all, so what is the time period to challenge that award? Is there any time period to challenge that award?
Yeah. In India, the award has to be challenged. That is a place where the arbitration is happening. If it is within India, the challenge time is 3 months.
Okay.
Post award, that is the date from receipt of the award or publication of the award, the losing party has 3 months. And further, there can be an extension of 1 month, that is 30 days, subject to providing valid reason. Beyond that, there is no possibility to dispense with the delay. That is a
Okay.
law, perfect law. And that challenge also is on very
Can you hear me?
limited grounds. If you look on the grounds role on that, the institution role ends when the arbitral award is given. Post award, it goes to the normal courts. And the 7 grounds, if you see the procedures on 5 and the other 2, non-arbitrable disputes if an arbitrator has dealt, or if the award is against the public policy of the country where it was published. Very limited grounds. The 7 grounds we can very well overlook. And when we opt for institutional arbitration, it is very clear that the probabilities of challenge on the procedural grounds are very, very, very meager.
Okay, sir. So thank you for it's an extremely helpful for our for your guidance on enforcing arbitration awards, offering much needed clarity to our members because that is the important thing. After award, what is the procedure for the implementation of that award? So that's sir. And finally, and anything else that you would like to share with our esteemed members regarding the model clause or the importance of arbitration for our businesses, both domestically and internationally, sir?
Yes, when we are coming to the model clause, my direct suggestion or opinions that when you members are interested to go for arbitration, literally adopt the model arbitration clause, what has been suggested by IAC. Don't ever adventure. The members, if you want, if you reach lawyers like me, at least I might be an exception because I am interested in arbitration. But most of the lawyers would try to adventure. No, you have to include this, you have to customize like that. But when you're interested to opt for institutional arbitrations, simply adopt the model arbitration clause, what has been recommended by IAC or any institutions you prefer. But why is all about these arbitration clause are well drafted arbitration clause and which ensure that when a dispute comes, there will be hassle free admission of those dispute or registration of those disputes by the institution. One. Second, the appointer would be made at the right time and at the right place. Third, that award would be perfectly maintained as a depository by the institution for a longer period. All these matters because the the problem what we are facing in an ad hoc arbitration, which has been addressed by institutions, all can be effectively implemented And here, when you look on these model arbitration clauses, the applicability of the arbitration rules of IAC, the seat of arbitration, the language, all would be perfectly included. And interestingly, the currency of the award also. I think IAC also is innovating with the model clauses. The currency of the award also better should be mentioned. Normally, when we see dealing with the dollars, or now we are also dealing with rupees in some countries, some with the Russian currencies, some with the Chinese currencies, all the currencies are differing. Arbitration award, the clause also can include the currency of the award. The model clause suggests. But one thing for us to look into or a final say to ensure the audience on the model clauses or the act. Arbitration supports neutrality, very important. Neutrality in dispute particularly international disputes, by providing a neutral forum. This is what I felt in my experience past 2 decades in arbitration, both domestic and international, particularly for the traders. When you're venturing into multiple jurisdiction, there are too much of complexity in the substantive and governing law, and too much of complexity in the contracts. Every country has a different contract law. And when you're dealing with European parties, it's even more vulnerable. China is much better than Europe when it comes to trade. But too much of directives, principles, and the civil law system, which is used in countries in Europe, creates a lot of problem because we come from common law system. In common law system, we have a normal law and we depends on the court decisions. But in civil law jurisdiction, they have voluminous of sections of law, the legal codified laws. That complexity and the conflict is there. If you take arbitration, and arbitration is going to be the only solution for all these disputes.
Okay, sir. So thank you for summing up that so well, sir. And your suggestions on model clause and the importance of arbitration act provide a strong foundation for our businesses to move forward confidently for arbitration and adding arbitration clause in their agreements and all. So, and that's it, sir. Thank you so much for your contribution for all our queries of our export members and all. So I hand over to Ma'am Swarlata ma'am to.
Yes, yeah, and this is in fact a very insightful session, and so many new learnings were there for me also. Though I am from international trade, and then too there was so much new that I could learn today, and I am sure that our listeners, our audience, they would be very much benefited with this session. And while choosing their arbitration institutions and all, they would be taking proper care, incorporating the model clause. That is one of the very important aspect that sir has spoken about. And people should carefully choose the model clause, and of course take the opinion from their institutions also. And of course, while choosing their arbitrators, if individual arbitrators they are choosing for, then too they should consider the confidentiality part. And of course, as said, the decision should be prompt. So all these aspects, sir has very well explained. And this was a session about the domestic and international also. We came to know about so many countries' jurisdiction, their procedures, their time frame, and all that was considered today. I am very much sure that people would be benefited with this session. And we invite you for any kind of questions, any kind of queries that you may have post this session, and that we would be forwarding to sir. And of course, he will be taking care of all that. If you have come across any trade dispute, that also you can bring to us, and we'll be forwarding that to sir. He may be guiding you, or he may be like your taking your case ahead. So this is how we would be going ahead. And on behalf of AECCI management, sir, I'm really thankful to you. Trust me, this was a great session, and so much addition to our knowledge today. And thank you again. Thank you very much, sir.
Yes, thank you.
Yes.
Have a
Thank you,
nice
sir.
year ahead.
Thank
Yes,
you.
sir.
Thank you, sir.